say. All right, so I'm Larissa Kaufman with the National Alliance for Safe Housing, and Carla Ng is joining us also as a moderator with the National Alliance for Safe Housing. And we are going to go ahead and get started so that you all can get the substance that you need. Jenny, next slide, please. Thanks so much. Okay, so as I said, the Domestic Violence and Housing TA Consortium is hosting the special topic series weekly for the next couple of weeks. And if you don't know about the consortium, just very briefly, there are several national technical assistance providers that work closely with the federal agencies that also focus on safe housing for survivors. They're listed above. And you can see our technical assistance provider team here. We also work really closely with other national stakeholders, including those on this call today who are presenting, the ACLU and NHLP. So let's go to the next slide where I think we are about to move into substance. All right, before we start, I have two other important pieces of information to share. One of them is that the substantive portion of this is going to be about 30 minutes. We invite you all to use the chat box, as several of you have been doing, to let us know that there were some tech issues and hearing one of the panelists. Please use the chat box for Q&A questions that you have. We are going to do our best to respond to the questions that come up in the chat box. We will also have about 15 to 20 minutes for Q&A, and Carlo is going to moderate that. So she is going to pull out questions that come up in the chat, look for common themes, and we're going to do our best to answer those towards the end. We also welcome hearing from you all on the ground in terms of what you are seeing, what is happening on the ground, what are survivors experiencing as it connects to being evicted or asked to leave their homes. So we want to hear from you as well. So now I can move on since I got through the logistics. One other piece is that this is being recorded. We are going to share the recording and other resources and information with all of you after the special topic. And we will also have it posted both on the Safe Housing Partnerships website as well as our technical assistance partners will likely have it posted on their resource pages as well, or linked to it. So you all will have access and be able to share it. Now, last but not least, we are finally moving into substance. Thank you all so much for bearing with us with the range of tech issues, and we can move ahead. So I'm going to go ahead and pass this on to Sandra and Linda at the ACLU, and I believe Linda is starting us off.
Thanks so much, Larissa. My name is Linda Morris. My pronouns are she, her, hers, and I'm with the ACLU Women's Rights Project. I'm here today with Sandra Park, who is also with the Women's Rights Project, who will be speaking a little bit later. But if we could go to the next slide and I can get started. So to start off, we'd like to discuss a few different potential housing issues that could be facing survivors of domestic violence and sexual assault at this time. So one of the things that we're seeing facing survivors right now is an increased threat of eviction. And so there's a few different ways that we're seeing an increased risk of eviction. And one of those ways is that even in states or localities that have eviction moratoria, there are still exceptions for criminal activity or for exceptions for evictions based on criminal activity or other lease violations. And so these types of exceptions or these types of evictions can disproportionately impact survivors of domestic violence or sexual assault who may experience abuse or experience other issues during this time that might result in their landlord evicting them. We also may see that survivors are facing the threat of eviction due to loss of income and economic abuse. So if a survivor, for example, is unable to pay rent or pay other bills because of either economic abuse or loss of income in some way, they may experience a higher threat of eviction at this time. Another issue that we are seeing come up and that we've heard from advocates is that there has been an increase in sexual harassment by landlords. So during this time, a lot of survivors are, you know, in light of the additional economic pressures related to COVID and the pandemic, many survivors are unable to pay rent, are facing other financial issues, or they're just, you know, more vulnerable and at the home because of the stay-at-home orders. And so we're hearing from advocates that there may be increases in reports of sexual harassment through either quid pro quo arrangements, landlords asking for sexual favors in exchange for rental payment. We may also see hostile environment sexual harassment claims where landlords are sexually harassing their tenants, and that harassment is so severe or pervasive that it is creating a hostile environment for survivors. Could you move to the next slide, please? So to talk briefly about the impact of eviction, what we know about eviction is that in addition to its immediate short-term harm, eviction often has a lot of far-reaching and long-term effects on people who experience eviction. Those impacts can range from job loss, medical and mental health issues, as well as chronic housing instability and even homelessness. And what we also know is that eviction disproportionately burdens women of color, and specifically Black women. And so what we know from different studies is that Black women are especially vulnerable to eviction as a result of many factors, including wealth gaps and pay inequities. And that creates a real race and gender disparity when we're looking at the impact of eviction. In addition to those disparities, eviction has very long-term consequences for people who experience eviction. And one of those consequences is the long-term effect of a prior eviction record on an individual's ability to access housing in the future. And this is often referred to as tenant blacklisting. So a prior eviction record can indefinitely block access to housing, regardless of whether that case was dismissed, occurred many years ago, or was filed unlawfully. And we've included a link here which has more information about the impact of prior eviction filings on individuals and their ability to access housing. Could you move to the next slide? So this year, the ACLU, in partnership with our data analytics department, did an analysis of eviction record data that we received from the eviction lab of the Princeton University through Matthew Desmond. And this eviction record data, through this eviction record data, we were able to do a race and gender analysis of not all states in the United States, but a large majority of states in the United States. And what we found was that Black women renters had evictions filed against them at double the rate of white renters, or higher, in 17 of 36 states. Next slide. And those disparities in eviction are even more stark when we look at state and local levels. So our analysis focused in on Massachusetts. And what we found was that Black women in Massachusetts were most likely to have evictions filed against them that were ultimately dismissed. And so what this means is that individuals in Massachusetts who are African American were more likely to have evictions filed against them, even in cases where they ultimately won. And this is important because what it shows is that these eviction filings can have a disproportionate impact on access to housing, even when an individual is able to fight those eviction filings in court and ultimately prevail. And so next slide, please. And so with that, we just wanted to give an overview of the types of housing barriers that are experienced by survivors right now and the impact on eviction. And with that, I'll turn it over to Renee Williams from the National Housing Law Project.
Great, thank you so much, Linda. And thank you everyone for joining us today. Next slide, please. So what I'm going to talk about is the federal eviction moratorium. And so as Linda really really did a great job in terms of setting up the overarching context around how evictions negatively impact survivors, negatively impact women of color, and sort of the particular urgency of evictions at this time, and making sure that in the context of COVID that we can keep survivors housed. I'm going to talk briefly about the federal eviction moratorium that you may have heard about in the news, or may have just heard about being discussed, and what those protections are and what they aren't. And then I'll briefly talk about other eviction moratoria, so eviction moratoria that are happening at the state and local level, and then round out with some practical considerations that you can use when thinking through issues with your clients, or trying to figure out what makes the most sense in terms of your particular client. So in terms of a federal eviction moratorium, what we're talking about is a piece of legislation called the CARES Act, which was signed into law in late March. And there's a lot in that legislation, but specifically here, I'm just going to talk about the eviction protections. So what the moratorium does is it provides landlords who are covered by the moratorium, and that's an important piece of this. Landlords who are covered by the moratorium from filing new eviction actions for non-payment of rent. And in addition to that, also includes prohibiting filing new evictions for not paying fees or other charges that are associated with non-payment of rent. Importantly, it also prohibits landlords from charging fees, penalties, or other charges related to non-payment. So an example would be landlords can't be assessing new charges. So say you have a client who, after the moratorium started, say April 1st, wasn't able to pay rent in its entirety. Not only can they not be evicted for that during the moratorium, the landlord can't assess late charges to the tenant, which is something that is pretty common practice that landlords will do. HUD has also noted in that Q&A that Larissa sent around, that talked about in the chat, this morning, also clarified that landlords can't be assessing interest on past late charges during the moratorium either. So say you have a client who in January or February was having difficulty paying rent, or was paying rent late, and they had some outstanding late charges. The moratorium and HUD's interpretation of that means that starting on March 27th through the end of the moratorium, landlords that are covered by this, and it's not all landlords, and I'll talk about that. I'm seeing some questions about the coverage, and we'll definitely talk about that in a sec. But in terms of these late fees, so landlords can't be compounding interest on outstanding late fees, which is an important point to note as well, because when we come out on the other side of this moratorium, there's going to be some issues about paying back rent, et cetera, and we don't want landlords to also be kind of compounding additional charges as well. So we'll talk about that, but I just wanted to note that existing late charges also can't be compounded during this time. So the eviction moratorium took effect on March 27th when the bill was signed into law, and lasts for 120 days, ending in July. And HUD has stated that that means July 24th. And then after the moratorium has ended, so starting on July 24th, there has to be an additional 30-day notice to evict a tenant from a covered housing program. And so, next slide, please. So in terms of the types of properties that are covered, somebody alluded to, and Carlo answered as well, but just to hit the point, to make a finer point of it, the federal eviction moratorium only applies to certain types of housing. So basically, a tenant has to live in a property that participates in what is called a covered program. So there are 4 categories that the law includes. One is the federal housing programs that are covered by VAWA 2013. And on the next slide, there's a little bit of a refresher as to what those programs are. Since we are talking, we are a group of DV advocates here on the line, I just want to make a side note that just because VAWA was included in this legislation, there's no impact on VAWA rights or protections in terms of the VAWA 2013 statute and the housing protections. Why VAWA was included was because VAWA really, tried to be pretty comprehensive in terms of the housing programs that are covered. And so that's why Congress decided to use it as a stand-in. But note, there were a few programs that were left out. Don't really have time to get into all of that today, but if you have a question about coverage, please reach out to us. My email is in the slides as well. So we have these federal housing programs that are covered by VAWA 2013. We also have the Rural Housing Voucher Program, which was one of those programs that was actually left out of VAWA 2013, but is included here. And then we have properties that have federally backed mortgages. So what that means is we're talking about housing that has an FHA loan, Ginnie Mae, Fannie Mae, Freddie Mac, Veterans Administration loans, HUD, USDA loans. So basically these government-backed mortgages. And we'll talk a little bit more about how to try and suss that out and find out whether a property is covered, but it's not easy. Here's the next slide that I was talking about in terms of just a quick refresher. So you'll see, oh, sorry, can you go back one slide? I apologize. So quick refresher on the programs covered by VAWA 2013. A lot of these are gonna be familiar, some maybe not as familiar, just depending on the types of housing that your clients live in. So public housing, the Section 8 voucher program, the project-based Section 8 assistance program. So, where the subsidy really stays with the unit, it's not a portable subsidy. A few programs within USDA, as well as the low-income housing tax credit program. And somebody, I think I saw a question in the chat about McKinney-Vento programs. Those are also included in VAWA 2013. One just really quick note about vouchers. And because generally when you have a voucher, you're using it, you might be using it on the private market. So HUD has stated that, if somebody has a voucher, it doesn't necessarily mean, it doesn't mean that the whole property is covered. But again, if you're trying to figure out whether your client lives in a covered property, I'm going to give some pointers at the end, but you can also reach out to us at NHLP and NASH as well. Next slide, please. So what is not covered by the federal moratorium? So I think somebody asked a question in the chat. I can't help but look at the chat sometimes. But in terms of what's not covered, so it's really important to know what's not covered. So one, I think somebody asked a question about, and I'm not sure if it was answered or not, eviction cases that were filed before the moratorium took effect. So this means cases that were filed in court. So basically the landlord had to start the process, the eviction process. Those are not covered by the moratorium. And that means that if a landlord filed an eviction action on March 26th, they can move forward with it even during the moratorium. However, just put to the side for a second, there may be state and local moratoria in place that may actually practically prevent that from happening, but just put a pin in that for a sec. There are also eviction cases that involve non-covered tenancies. So meaning private rental housing is basically what we're talking about here. So things that are strictly on the private market that don't have any of that federal subsidy. Eviction cases based on anything besides non-payment of rent or the associated non-payment of fees or charges. So as Linda mentioned, criminal activity, other lease violations, housing providers that are otherwise covered by this moratorium can still proceed under the CARES Act. Next slide, please. So now that we sort of have a framework of the federal moratorium, it's also really, really, really important to check your state or locality to see if they have an eviction moratorium. And a number of states and localities have moratorium on evictions, but it's really difficult to make a very general statement because they're all sort of operating differently. They have different features. They may or may not stop at different points in the process. One thing that's really important to note is that the state or local moratorium may be more protective. For example, they may cover private housing. They may cover housing beyond what's covered by the federal moratorium. And that moratorium would govern if it's more protective. So that's something to know. But at the same time, some of these moratoria in other ways may be less protective. One really big example is under the CARES Act, it's for anyone who did not pay rent, right? That for any type of non-payment is protected from eviction. So if I'm a household, and even if I wasn't economically impacted by COVID and I didn't pay my rent, I can't be evicted under the CARES Act. However, certain states may, for example, require that a tenant demonstrate economic hardship due to COVID-19. So again, you really have to kind of parse through that and figure out where the protections lie. And unfortunately, it is sort of this mishmash of protections. At NHLP and other places too have been tracking the moratoria. Definitely use that as a kind of first resource for further investigation. One practice tip, or one really important practice tip, is please don't rely on how an eviction moratorium is discussed in the media. We had this experience in California. Local news is great and they provide a lot of really great information, but they may not be talking about the gaps in the moratorium, things that are not covered. So in California, the governor had signed an executive order and it was being reported in the media as a moratorium. But when landlord-tenant attorneys were looking at it, it wasn't actually a moratorium. And that has been subsequently addressed by the courts. But you don't want to just rely on information. And so I definitely encourage folks who are not landlord-tenant attorneys to talk to a tenant lawyer to understand the practical implications. Like, does my client, can my client still default if an eviction notice is served and they don't answer, even though they might not be physically removed from the property until the emergency or the pandemic is over. So again, just really important to understand those finer points. Next slide, please. So one really important consideration, and I think it's one that's, a lot of folks, there's been a lot of conversation about. So an eviction moratorium doesn't mean that there's cancellation of the rent owed. So this is simply a pause. And so, a couple of things that you can do in the meantime. And, I think Linda made a really important point about, the impact of eviction. So basically, after the moratorium is over, HUD is basically saying that, if a tenant doesn't repay rent or, enter into some sort of repayment plan, they can be evicted down the road. And as Linda talked about, eviction has a lot of downstream consequences. So this is something that you definitely have to keep monitoring, but it doesn't mean the cancellation of rent owed. And so while there are not fees that are being assessed, you may have 1, 2, even 3 months of rent, back rent that's owed when the moratorium is over. So right now at this time, and everything is sort of constantly evolving, but as of today, rent still has to be repaid after the pandemic ends. One thing that you can do if you have a client in one of the federally subsidized housing programs that base rent on income is that you can have your client request an interim recertification. It's unclear the extent to which these federal landlords are promoting this among tenants, But the idea is that when there's a loss of income in the household, or, you know, honestly, if you're a survivor and the abuser is evicted, you can request an interim recertifications to reflect the lower level of income in the household so that your base rent is lower. So that's something that we're definitely encouraging folks to do now, even during the pandemic, and to try and get on that right away, because a lot of providers, a lot of housing authorities, they're all working remotely. And so try to get those interim recertifications in as soon as possible. We do have, our partners rather, have a resource to try and figure out, you know, does my client live in one of the properties that are covered by the federal moratorium? They can consult this resource the National Low Income Housing Coalition has put together. It is not an exhaustive resource by any means, and actually on the website, it kind of spells out, you know, the types of housing that are included, types of housing that are not included. Two sort of big exclusions would be the voucher programs. So the Section 8 vouchers, the rural housing vouchers are not going to be included in that database. Again, if you have questions, you can definitely reach out to us at NHLP to try and kind of walk through what you would look for to try to determine what type of housing your client lives in. Next slide, please. So just a couple of other really quick things. So as I mentioned before, you know, both in terms of the federal moratorium, and Linda mentioned this for the state moratoriums as well, a lot of these moratoriums have carve-outs for basically issues that are not related to payment of rent. And so I think one of the important things to note, as we know, survivors are often evicted because of the abuse committed against them. And, you know, Sandra is going to talk about the protections that are in place to kind of, you know, take the place of these gaps. But just know that, you know, it's really, really, really important, even if the moratorium is in place, if a client receives anything that looks like an eviction notice, a notice to vacate, they should consult a housing attorney immediately to discuss their rights and options. Because as I mentioned, you know, all the moratoria, it's a patchwork. You want to make sure that the client's rights are preserved and then they're not missing out on any opportunities to, you know, provide information or do anything. So even if there's a moratorium in place, or it looks like there's a moratorium in place, to confuse things even further, landlords can still send reminder notices, at least the ones in the federal programs can still send reminder notices about past due rent. And so it's really important, you know, if a tenant receives a notice and they're confused or concerned, or if they have limited English proficiency and the notice is not translated, again, try to talk to a housing attorney so that they can parse through what this actually means and what next steps may be necessary. I think that is it. Let's see, I will, looking for some of the questions, and I will try to get to them during the Q&A, but I want to pass it on to Sandra. But please keep the questions coming, because this is a really important piece. Sandra, I believe you're up.
Great, thank you, Renee. Hi, everyone. My name is Sandra Park. I'm an attorney with the ACLU Women's Rights Project, and I use she, her pronouns. You know, I think we were going to do a very quick refresher on existing housing protections for survivors, because as Renee mentioned, there are some, you know, very important first steps in terms of eviction moratorium that have been adopted both at the federal and in some state and local levels. But there are a lot of situations that are not going to fall within those. And then there are also going to be situations that are specific to people's experiences with violence. So I just wanted to do a very brief overview of what some of those protections are. And, you know, obviously we're all happy to talk more about these situations if you have people you're working with who are facing them. So at the federal level, there is the Violence Against Women Act, which Renee mentioned, and those are protections specifically for survivors of domestic violence, sexual assault, dating violence, and stalking. And they apply to those programs that Renee had listed on an earlier slide, most notably public housing, Section 8, and low-income housing tax credit-funded properties. And VAWA contains a bunch of different protections. The key one is prohibiting denial of housing or eviction based on violence. VAWA also provides for lease bifurcations, certain confidentiality provisions, voucher portability for those who hold vouchers and need to leave earlier than their term and want to port that to another location. And then it also requires covered housing providers to adopt a plan for emergency transfers when the reason you need the transfer is connected to your experience of violence. So that's a very, very brief overview of those protections. We also have the Fair Housing Act, which applies pretty much to all properties, including privately owned properties, with some very minor exceptions. And the Fair Housing Act does not specifically name survivors as a protected group, but it has been used by lawyers and advocates to prohibit discrimination that survivors experience based on the prohibition on sex discrimination. It also prohibits discrimination based on race, disability, and national origin, and other types of characteristics that survivors may have that are then targeted in relationship to their experience of violence. And so sort of the classic way that the Fair Housing Act has been used is where, for example, a landlord is taking action against the survivor because, for example, the survivor has experienced domestic violence, but would not take similar action against another tenant who had experienced a different form of violence or crime, for example, burglary. So that is an important protection. It also includes protections against sexual harassment. And so as Linda mentioned at the start of the webinar, we have been very concerned about the rise of sexual harassment or the possibility of sexual harassment by landlords during this pandemic. And so it's an important reminder to note that the Fair Housing Act specifically protects against forms of sexual harassment in housing, and there are regulations and other forms of law to really implement that. I've listed here links to two sets of resources. There are many more, but that cover these federal protections. But I think those are good starting points if people are looking for more information on the federal side. Next slide. And then at the state level, there are also additional layers of legal protections in many states. And some states have specifically included victims or survivors of different forms of domestic violence, sexual violence as protected classes. So along with, the fair housing protection against race discrimination, sex discrimination, and the federally recognized protected characteristics, some states have also added status as a survivor of domestic violence or sexual assault as a protected class. Other states have not done that, but they have adopted protections for survivors nonetheless, such as giving survivors an eviction defense if the eviction is connected to their experience of abuse. Some states have provided for early lease termination if a survivor needs to leave their lease early. There are also some that allow for lease bifurcation, lock changes, and a myriad of other measures. And I think the best resource on, finding out what your state has, if you're just wanting a starting point, is looking at the National Housing Law Project's compendium on state law. And your state may have more recently adopted new updates, and so it's always good to check on that as well. But I think that compendium does a great job at collecting what so many states and localities have done. And then I also, think that the state fair housing laws also provide an additional source of protection. And at the state level, you can, as Renee said, I think the first step in any of this is hopefully for people to be able to consult with an attorney on what the legal options are. But there are also options in terms of filing complaints with the state Human Rights or Civil Rights Commission, or sometimes those kinds of commissions exist at the city level. And then at the federal level, HUD accepts Fair Housing Act complaints. And so just to give folks a reminder of those places that do accept complaints on these issues. I think now I am going to turn it over to Linda, and she's going to just briefly talk about some of the advocacy we are doing right now, given everything that we've just covered. Linda?
Thanks so much. So like Sandra said, there's a lot that can be done at a state and local level to advocate for stronger protections against eviction for survivors of gender-based violence. And so I think first, starting off, as Renee mentioned, it's important to understand what protections currently exist in your state, and to understand whether a survivor is covered by any existing moratoria, including the CARES Act or including anything more local. So in addition to the CARES Act, many states and cities, as Renee mentioned, have issued their own moratoria on evictions, and importantly, some have not. And so Renee shared a resource on her slides for checking state and local moratoria. The Eviction Lab also put out something yesterday, a guide for checking every state's moratoria or lack thereof, which can be found through this site on this slide. And just to reiterate a point that Renee raised, it's really important to look at the actual order or proclamation that your jurisdiction has issued. These are great resources, but oftentimes it helps to go straight to the source and get a better understanding of what your state or city has actually implemented. In addition to understanding what protections currently exist where you are, the National Housing Law Project has put together a really incredible collection of resources on eviction moratoria and protections that exist for tenants. And so I've provided a link to those resources here in this slide, and that can be a great place to find out more about the CARES Act and the federal moratorium that exists right now, as well as guidance on what makes an effective eviction moratorium. And in addition to those things, so the ACLU will be working with our state affiliates across the country to advocate for states to issue their own moratoria if they haven't already, or to expand upon existing moratorium. And so if you're interested in engaging in statewide advocacy where you live, please feel free to reach out to myself or to Sandra for more information, and we'd be happy to connect with you. And the last point that I'll mention is, in addition to these moratoria, a lot of organizations, including the National Housing Law Project, have been advocating for guidance from HUD and other agencies to really clarify what protections currently exist for all tenants, but also for survivors. And so there may be ways for you to further engage in that advocacy as well. But that is all I have. And so I guess I'll turn it to, I think, Carlo for discussion and questions.
Thank you so much, everyone. Thank you to Renee, Linda, and Sandra for that wonderful information that's much needed right now. I just want to remind everyone that the slides and the recording for this call are going to be circulated after this call. So for folks who are asking about the slides, please wait a day or so and you'll get those links to both the slides and also the recording. Oh, there's also a question, okay, about contact information for the presenters. I believe there's a slide on that as well. I think there are some folks on the call who actually called in and may not have access to video. And so for the folks who just have the audio, I'm going to go ahead and read out some questions that have actually already been answered in the chat. But if folks can't see the chat, they won't be able to see the answer. So I'll go ahead and highlight those as well. So there are quite a few questions that came in about the federal eviction moratorium. I sort of categorize each one of them. The first set of questions is about coverage. So in terms of the federal moratorium, there are questions about whether or not certain programs are covered. There's a question about whether or not the COC Rapid Rehousing Program is covered. And since that's a McKinney-Vento program that is covered by the federal moratorium, there are questions about how do you generally figure out whether or not someone is in a unit that is subsidized by a program that is covered by the federal moratorium. Can someone answer that?
Sure. This is Renee. There are a few ways. In the PowerPoint, there is, in my section of the slides, there is a link to the National Low Income Housing Coalition database and mapping. They've been trying to gather this information to the extent possible. But as I noted, that is definitely a starting point. For some programs like the Section 8 voucher program, those are not going to be included. So a couple of other ways to figure that out. One, if your client deals with the housing authority, it's very likely that they're going to be in either public housing or the voucher program, but they can reach out to the housing authority to get clarity on what type of housing that they're living in, because sometimes housing authorities also manage other programs as well. So it's not a perfect one-for-one. So you can reach out to the housing authority. You can ask your housing provider to tell you what sort of subsidies are on the property. Other ways would be, for example, if you don't know if you have a rural housing voucher, you can actually contact rural development and they would be able to tell you. So there's a lot of different ways. There also, if your client is working with an advocate or an attorney, if they have a copy of their lease, that will provide some clues as to what type of subsidy there is. So it's a little bit of investigation and it's not, all completely neat, but I would definitely encourage you, to reach out to myself or the folks at NASH to kind of, walk through what that might look like, depending on, where your client is living. So step one would be use the National Low Income Housing Coalition database as a starting point. And if you don't find anything there, definitely reach out and we can help you sort of figure that out.
Great, thank you, Renee. And just a note for those who might be working with survivors who are funded through the Continuum of Care or Emergency Solutions Grant Program, those homeless assistance dollars are often more flexible than some of the mainstream programs like public housing and Section 8. And because of that, survivors and also the recipients, the nonprofit recipients of these dollars, can actually go into some of those funds to get additional financial support, especially during these very difficult times. So things like rental assistance, supplemental rental assistance, security deposits for transfers, etc. You can request additional funds for those purposes in the COC and ESG programs. There was a question about whether or not all landlords, including large complexes, are banned from charging late fees. And I believe Renee answered that during her presentation. Basically, the federal moratorium only covers the programs that are covered by VAWA, which are certain federal housing programs. And so if the landlord is subsidized through those federal housing programs, and they'd be covered by the eviction moratorium, the federal one. There's a question about, is the moratorium only for tenants who qualify due to loss of income because of the coronavirus, those who have gotten the virus or are in quarantine?
I can, this is Renee, I can answer that as well. So that is one of the really helpful things about the federal moratorium. It is across the board prohibition on evictions for non-payment or for the non-payment of fees associated with the non-payment, meaning it can be for any reason. It could be a tenant, you know, just for whatever reason, you know, lost their job, but may not be able to document that there's a connection to COVID, or there's no connection to COVID. It is across the board an eviction moratorium. And that differs from, you know, some of the state moratoria. So again, you know, if you're looking at your state moratoria, there may be additional requirements, or there may be a narrower set of folks who are protected. But for the federal one, it's anyone who's missed a rental payment.
Thanks, Renee. These next set of questions has to do with reasons for eviction. If people are paying their rent, but they are in violation of their lease, can they be evicted right now? So for example, if folks are doubling up, which we all know folks are living with each other because of the virus, is this something that folks could be evicted for under the federal moratorium?
I'll take that one as well, unless Sandra or Linda want to take it or want to chime in. So the answer is that the federal moratorium is narrow in the sense that it applies to non-payment only. It doesn't apply to other types of lease violations. And, you know, as Linda and I believe Sandra also mentioned, you know, one issue where that might arise is if there's criminal activity and that's the reason for the eviction, and, you know, a survivor is being evicted because of quote unquote the criminal activity. So survivors could still be at risk even under the federal moratorium. So it's really important. As I mentioned, you know, if there is an eviction notice, to really get that under the eyes of an attorney, an eviction defense attorney, quickly. And then in terms of issues like doubling up, you know, I know that has happened. As far as I know, HUD has not issued any particular guidance on that piece. I did see in the Q&A this morning, they did talk about abandonment of a unit and the step, because, you know, folks maybe have left the unit to quarantine with other family, or maybe, you know, spending time with other families. So they did address the issue of abandonment and how, you know, housing authorities need to be mindful of the circumstances. But I will say, if folks are doubling up and it's related to a disability, so for example, maybe somebody needs care related to a disability and no one else can provide it because of the pandemic, you might be able to request a reasonable accommodation. And as long as their presence doesn't violate any sort of health or safety codes, there's a good chance that, you know, somebody might be able to stay, you know, at least a little bit. But, you know, of course, every situation is fact specific. But think about tools like reasonable accommodations that might be able to apply here. But yes, they can still be evicted for lease violations like that, I should just mention.
This next question has to do with, it's partly sort of a question that I want to pose to so that folks are aware. Sandra and Linda mentioned that there could be reasons for eviction that are related to the domestic violence that is committed against an individual. And sometimes, you know, that reason for eviction could lead to an eviction, but the actual reason for eviction might not be that there was domestic violence that occurred. So I was wondering if you could provide some examples for the audience of what that kind of eviction could look like in real life so that advocates could be on the lookout, and what should advocates do if they think that there might be an eviction that's related to domestic violence and is a violation of VAWA or the fair housing laws.
Sure, I can start, and Linda, feel free to add. Yeah, I mean, there are times when the landlord will, on the eviction notice, actually say something about domestic violence or a violent incident. But the more typical scenario is that there's some other reason that once you actually look into it, it is connected to violence, but the notice itself will not necessarily make that clear. And it's also possible the landlord doesn't necessarily know about the connection. So, you know, there could be situations of what's considered unauthorized occupancy, where the abuser may not live, officially be a tenant in the home, but is often coming to the home, often forcing, you know, stays there. And the survivor then may be subject to unauthorized occupancy evictions because the tenant has, in the landlord's eyes, allowed somebody to be present and residing in the home in violation of the lease. So that's one type of scenario. Another type of scenario is around property damage, that the unit sustains some form of property damage associated with the violence, and the eviction that is based on property damage. And there again, you would want to be able to do advocacy, both first informing the landlord of the actual basis of whatever the property caused the property damage and how it's connected to violence, to be able to then invoke the legal protections, whether under the federal law or under state and local law. Another type of scenario could be, you know, economic related abuse. You know, there may be situations where a tenant is unable to pay rent because their funds have been withheld from them due to economic abuse. And, you know, there has been some very creative advocacy done to, in some cases, to connect that economic inability to pay, or what's seen as a failure to pay, with the history of economic abuse in an intimate partner relationship. And again, that's where advocacy would be so important in terms of helping to explain that the reason rent was not paid is connected to a larger cycle of economic abuse that landlords either may not understand or may not be aware of. And so I think, again, trying to explain that situation and putting landlords on notice that domestic violence in that type of scenario is at issue in the case. And then, you know, another situation we've worked a lot on is where there are situations where abuse or violence is considered to be disruptive to other tenants or to the property. One way this is often triggered is if there are calls for police service, and landlords consider that a nuisance or disruptive to other tenants at the property. And again, you know, making that link and telling the story of how those calls for service are connected to the experience of domestic violence or sexual assault is really important in terms of invoking the legal protections that might apply in that type of scenario. So I think those are the ones I see most commonly, but Linda, is there anything more you'd want to add?
No, I think those are the types of situations that I can think of immediately. I would just add that especially on the economic abuse piece, we have worked on matters where that advocacy has been really important to sort of draw that just really like make that explanation clear to a court. And so I think to the extent that we can provide resources that would be helpful on that point, I would just offer again to reach out to us.
Thank you so much. That was very helpful. There are a few questions about a post-federal moratorium and what happens if folks owe rent. So for example, if a person does owe a significant amount of rent, whether it's double or triple the amount of rent that's owed monthly, they understand that they cannot be evicted for non-payment of rent during this period of time when the moratorium is in effect. But can the landlords request all of the owed rent at once the moratorium expires? So essentially there's a balloon payment once the moratorium expires.
This is Renee. That's a really good question. I think what HUD is doing right now is to encourage owners that are covered by the moratorium to enter repayment plans. I'm actually looking right now at the notice that went out this morning. What it says is for any unpaid rent during the moratorium, the family must repay the housing authority in this case, or sign a repayment agreement to pay the amount owed after the moratorium is ended. I think it's really unclear as to what is going to be permissible at the end, of the moratorium. I think that's still, sort of an evolving issue. I will say, and just one thing that I want to reiterate that I mentioned before, that if you do have a client who's living in federally assisted housing that is covered by the moratorium and their rent is based on their income and they've experienced a significant loss of income, such as loss of a job, they should really try to get the ball rolling on getting an interim recertification, because that will, the idea is that that will reduce the overall amount of rent owed. But I completely understand the concern. And so as we get closer to the end of the moratorium, it's likely, but not guaranteed, that perhaps HUD will issue more guidance on this question. But right now, it's just sort of, the discussion is really limited to, talking about repayment agreements. But there's not a ton of information right now, but it is conceivable. There may be some arguments as to why that would not be permissible, but again, we just kind of have to wait and see at this point, which I know is not a huge comfort, but one of the things that can be within a tenant's control is to get that interim recertification process going.
Thanks, Renee. So Renee raised some very, very important points. So the recertification is really important for families that are experiencing an income loss, and therefore during this time, the amount of rent that they owe should decrease and therefore their subsidy should increase. And so getting that certification will get the ball rolling in terms of having folks get a larger subsidy during this difficult time. And then it sounds like, based on the HUD guidance that we've received so far coming out of HUD Central, that really repayment agreements and negotiating for repayment agreements at the end of the period where folks might be owing more rent than they normally would because of the crisis, that those negotiations are encouraged during this time. So advocates working with survivors who might be facing those circumstances should definitely work towards negotiating with landlords and owners on behalf of survivors. So we are actually at the end of our time. I just want to remind folks that the resources, the slides, the recording, we're also going to have a Q&A that's related to domestic violence, sexual assault, and safe housing during the virus up on our website. We'll have many of these questions that were answered during this call and also previous calls and calls in the future also included as part of that Q&A. So if folks want more information, please visit those resources. And I just want to thank you once again to all of our presenters who provided such great information during this critical time. Thank you to Sandra, to Linda, and also to Renee. Take care, everyone, and have a great rest of your day.